with the world of design and the arts. Our exhibition is actually currently not up, which is a pity, and I'm not quite sure why, but we have a gallery here as well, where we showcase art and tech exhibitions, and we currently have an exhibition by Zurich-based artist Melo Buse that explores physical bodily perception in the virtual space. And so we have changing exhibitions here, lots of events. Please come back and join us again for discussions here that tend to be very interactive also. And it's a pleasure for us to actually work with the Hive tonight. It's our second hosted event that we do together with the Hive. We've known Ravi for quite a while, so it's really great to collaborate. And before we pass the word actually on to Ravi, I would love to introduce you to our Consul General, Benedikt Wechsler, who will give a few introductory words to also tell you a bit more about how Switzerland stands with respect to GDPR, etc. Thank you very much.
Thank you, Joya. As I mentioned, when you came here, you were passing by the Swiss Consul General, we have the Swiss Business Hub, we have Switzerland Tourism. So it's a bit of a Swiss pier here in San Francisco. And as you maybe know, Switzerland is a landlocked country, so for us to being on a pier is like a little bit destabilizing, disruptive. But I think it's a good place because, you know, we're entering into new territories, and when we leave our mountain valleys and go into the sea, you ask yourselves a lot of questions. How is that world going to look like where we're entering? And I just want to tell you a little Swiss San Francisco anecdote. This book called Gold is written by a famous Swiss French-speaking author, Blaise Sandra, about the life of General Sutter, who was a Swiss who came in the 19th century to San Francisco and actually discovered gold here. Now, Sutter, he came from Switzerland because at that time, when you went bankrupt in Europe, you could go to jail because your creditors would put you to jail. This practice is happily over because otherwise I think that the prisons around here would be very, very full. So we had to flee Switzerland to come to the New World. And of course he was very happy because now he said, well, you know, I made it now. I have gold, I have, he was the biggest landowner of California. But then he felt, you know, what happens when you're in a world, you discover something, you think it's yours, but there are no rules and there's no institutions who can protect your rights and your obligations. So he got run over and he ended as poor as he came. 73 years old, he would have been the most wealthy person in the world, and he ended in bitter poverty. And, you know, when we look today, I hear a lot of people saying that data today, it's the gold of the 21st century. And, you know, in a way, I think we're in a similar situation. We're actually on a rich wealth of information, which can improve our lives, which can make the people more happy and more capable of determining themselves. But on the other hand, also, we have not yet the rules, I think, where we agree on. We don't have the institutions yet where we can rely on if we are feel being violated and everything. So it's actually a quite nice parallel, and I'm so happy that you are here. That people also from the industry who really know what they're talking about, because I am as a diplomat, you know, we have the reputation that we are capable of talking everything about anything, but not knowing very much in depth. But you are the expert, and we need you, but you don't know how the politics are working and the legal framework. And I think that is places like this where we have to come together and breed good rules, good institutions to really make the maximum out of this great potential of the use of data for a better future. And Switzerland, for us, you know, we're around since more than 700 years. We have some experience in institution building. Geneva, with the UN, is one of the main hubs of the global governance issues. And we made it also a priority for the Swiss government that we want to shape a world where data can be shared by everybody in a democratic and equal way. And I think also, you know, Switzerland is not a member of the European Union, although I think the European Union does a lot of good things in that area, and also with GDPR, I think that is for us also a very important leitmotif. And I think that also as a place where you can discuss these issues in a more neutral way. I think Geneva in Switzerland is also very well placed to be such a dialogue platform. And I'm very happy that this dialogue also is taking place here. And I'm really looking forward to the discussions. And I hope you have a great evening and bring something back to your workstation or your home from Switzerland. And please come back. As Joya said, there are many other interesting events coming up this year. And I pass over the word to Maddie. Thank you very much.
Hi everyone, and a big thank you to SwissNex for hosting tonight. By a show of hands, who here has been to a Hive event before? Okay, good. We need to get more of you guys out though. So I'm Maddie, I work at the Hive, I run the people and programs operations, and I also run the Hive think tank, and we are bringing events to you guys 1 to 2 times a month, as well as we have an online platform where you can read more about what we're looking into, what aligns with our investment thesis. We are running events related to AI, blockchain, 5G, fintech, insurtech, among other things, and our goal is to create and foster an ecosystem of entrepreneurs, corporations, and other data-driven individuals. So we've had over 200 events, we've touched the lives of over 11,000 people, and we are also hosting another event next week. This one is going to be virtual though. This is going to be a webinar, so if you are interested in signing up for our event, you can find all of our stuff online at hivedata.com. And if you guys tag us tonight, we'd really appreciate it, so please feel free to take pictures, use the hashtag Hive Data. And we'd also like to thank our sponsors. So if you are somebody that is interested in working with us, or your company is interested in working with us, please reach out to me. You can find me in the back, or you can email me, maddie@hivedata.com. I would love to introduce our co-founder and managing director of the Hive, none other than TM Ravi.
So first, it's a great pleasure to be here, and thank you, Counsel General, for hosting us, and Joya for hosting us. I've known Joya for a long time. My first connection with SwissNex goes back to something related to Burning Man. So what happens in Burning Man stays in Burning Man. But the great thing about the Swiss consulate and their infinite wisdom, they gave a grant to SwissNex to create like an installation which they took to Burning Man. And I was fortunate enough to buy a piece of that installation subsequently. So thank you. As you heard before, the topic today is very important. I would say Switzerland rightfully can take a lot of credit for early awareness of privacy, and you see sort of it resulting in GDPR, and today's topic, CCPA. The Hive is a venture capital fund. It's a certain kind of venture capital fund which tends to be called a venture studio. So we fund like venture capital, Series A, Series B, Series C, that kind of thing. But we are very operational and help companies very actively in the first 2 years. It's not an incubator and accelerator, so we do 2-3 companies a year maximum, and fund them kind of throughout their life cycle. We have since 2012 had the point of view that data and data-related techniques, AI, is going to change the world, is going to change our lives. Our focus is on the enterprise, and so we think thematically about how AI is going to impact different areas, different industries, and look for opportunities for us to create large companies there. These are kind of a set of our companies. I won't go through them, but one of our companies is standing behind. It's called Data Secrets. It's in the privacy space, so I hope you'll have a chance to talk to them. I'm also involved with another company, Denodo. The CEO is here somewhere, Lydia. So they're in the data management space, enabling kind of privacy in the back end. And so as Maddie mentioned, please, if you're on Twitter, use the hashtag Hive Data so people can follow you. With that, I'd like to introduce the panel today. And so it's a great pleasure to have Lydia F. de la Torre, who's, all of you wanted to come over, and who has a dual kind of responsibility. She's a faculty member at Santa Clara University, and she's at a law firm, Squire, Patton, Boggs. Stephanie Adamson King, who's at Twitter as VP and Deputy General Counsel there. Andy Roth, who's the Chief Privacy Officer at Intuit. Michael Hauser, Global Privacy and Data Protection at Pinterest. We participated, the Hive participated in the IPO of Pinterest, so thank you. I wish it had happened in a different year. Last year was a tough year for IPOs. Joseph Tanaski, who used to be at Facebook actually, and has just recently left Facebook, so don't blame him for anything. And Robin Andruss, who's Director of Privacy Governance at Twilio. So you'll see sort of from the collection of people here that it's not just online companies. Twilio and Intuit are examples of companies that are not online companies that have to deal with privacy and privacy regulations. So with that, I'd like to hand it over to Lydia. And Lydia, what are the rules about Q&A from the audience?
Thank you. So we have kind of organized this as a conversation, and at the end of the conversation, there will be an opportunity for you to ask questions. So if you do have questions, we'll ask that you hold on to those questions until the end, and we'll try to get to all of them. Thank you for the nice introduction. This is an amazing space. I'm in the South Bay, so every time I see the ocean, I kind of get excited about that. And this is a very interesting topic and a fantastic panel. Thank you everybody for being here. So my day-to-day work, I actually get people, the people who are sitting here calling me and asking me questions that are not easy to answer typically. And today I have the privilege of asking the questions and seeing what the answers are. So the topic that we're going to talk about is in general how regulating data is impacting innovation. The most recent data law that has been enacted and just recently became active or enforceable is the California Consumer Privacy Act. So that's a little bit of excuse because we know there will be other laws, there were laws before it, and people who work in privacy have to kind of deal with this moving target of what does compliance mean. So I just wanted to quickly, I guess that's us, just give you an overview of what this new law is. The California Consumer Privacy Act is a California law that was enacted in 2018 with the goal of protecting the privacy rights of California residents. The story behind the law, I think, is important to give context as to why it's a little bit different from all the things that we have seen. It started as a ballot initiative. So a couple of fairly wealthy individuals who were concerned about, what organizations were doing with data put together a proposal for a ballot. Here in California, we do have a system where individuals can propose laws and they get voted on, and if you get enough votes, they get enacted as law. And the proposal was, you created a number of pain points for the industry. Eventually, actually, what happened is it was withdrawn in exchange for Sacramento enacting this new law, the California Consumer Privacy Act, which is a little bit different from the initiative. There were some major changes in terms of enforcement, in terms of some of the rights. But I think it's really important to realize that this was conceived as something that had to be explained to voters in commercials, and they had to decide whether they were going to vote yes or no on this proposal. So the agency that's enforcing it is the Attorney General of California. Right now is Xavier Becerra, and it fundamentally provides 4 rights to individuals. We have the list of them here. I think that there are some materials I believe that the Hive has put together that have more background in the law for those of you that might want to dig into it. But it gives you the right to know, which is the right to access personal information about you. It gives you a right to delete, which is quite different from the European right, in many ways more limited. It gives you a right to opt out of data cells. And this is the one right that is fundamentally different from the structure that we have seen coming from other jurisdictions, and I think the one that has caused more questions for organizations. And the last right is the right to not be discriminated against if you choose to exercise those rights. So with that short introduction, I have to say that everybody in this panel has probably spent hours trying to understand this law, which is explained here in 5 minutes. But I was wondering if maybe Joseph, you could describe for us how you have seen through your career data being an important factor to innovation.
Sure, so the first thing I would say is that my work history is fairly random. I don't think it was really planned out in advance. So I've worked for some interesting companies and on some interesting products, but it's probably not a perfect sample. I think when I first started out, I remember companies having traditional databases and thinking about the data they were collecting on their customers and doing payroll and very traditional sort of things. And they mostly got leverage out of just being able to do that at what they considered large scale. And then there were companies doing desktop software where they would try to get control of a format. So you would see companies competing with each other over like what's the format of a word processing document. Whoever had the preeminent editing application would tend to win the format fight. And so their power was sort of exerted by a sort of informal standard over control of the format. I think as you go to online services, you see companies being able to collect much more data on a much bigger scale. People don't really appreciate, like when they use a website, just how much information is being collected and how useful that can be to sort of profile them later. So that's sort of the regime we're in now, is that everyone is collecting massive amounts of data. And then I think this leads to another interesting problem. At least in the original systems, people would have so little data that they would carefully curate it. They would worry about its accuracy. Now we have so much data and so much of it that we never see. It's just stored somewhere or maybe examined by an online system or a machine learning system or something else. So we think about it statistically. And when you actually do expose it to the end users, not only are they upset about what they see, like anyone who's ever looked at their own credit report sees all kinds of craziness on there, and they're like, where did that come from? But it's even worse if you could see like tracking information. Facebook just released a feature recently called Off Facebook Activity. And when we first started talking about this feature, we were talking to people who owned websites. They used Facebook's tracking system. They self-reported a lot of information about how their website was used, but they never thought that their own customers would see that data. So they never worried about how accurate it was. They only used it for their own reporting purposes. And when Facebook went back to them and said, oh, by the way, we're going to show that data to your users, it was just total panic. It was like, how will we go and correct all that data? And they tried to correct what they're collecting now, but that doesn't do anything about the historical data that you're exposing to users, which is just a disaster. When you see it, it's just completely wrong. I think going forward, we'll see the same kind of thing happen in sort of everyday life that has happened on the web. So if you think about your phone, it's basically a package of different kinds of sensors. It's sensing sound and temperature and light and magnetic fields, it's got all kinds of crazy sensors. And it's constantly recording information. And the volume of that information is incredible. If we kept all of it, I'm not sure where we even keep it or how we transmit it all, but if we kept it all, it would be really incredible. And people don't think about how much could be recorded about them just by their act of carrying a phone from place to place. So then you say, okay, now there's going to be devices in your home you can talk to, like your phone, but they're sort of stationary, and there's going to be cameras wherever you go, and self-driving cars and so on. So all of these things are basically sensor packages that are connected to the internet. And just like a website, they're going to record streams of data about it. So that's not a very positive message, I guess, but what I would say is the amount of data is only going to keep increasing, and the amount of it that you would think of as private in the past will also be increasing.
Right, that's very interesting. And I think everybody can, you have the experience of having lived for 20, 30 years and remember the time before the cell phone, right? So we're living through this change. And it connects with the regulations and the CCPA because the main framework that we have used in the past to think about how we regulate data is the European framework, and that started in the 70s. It was conceived in the 70s. So think about, what they had in mind when they conceived this system. I mean, we didn't have cell phones, we didn't have, AI. I mean, it was a completely different universe. So the framework was conceived as really heavy on obligations, but it was meant to be imposed on a limited number of organizations and situations. Now we are digitalizing everything, which means there's a lot of uncertainty. I was going to talk about this point. There's a lot of uncertainty about even how the old framework applies to these new technologies. And now with the CCPA, I think we have another round of uncertainty because it was, one of the things that can be said about CCPA is that when you think Sacramento is slow, think again. I mean, in 1 week they got this thing approved. That was the time that they had before the, limit for the proponents to be able to withdraw the proposal came up. So in 1 week they broke a deal and they approved this thing unanimously. So it worked, right? These things can happen. But there's now a lot of uncertainty because it's different, right? It's different from the prior frameworks. We are still in the process of enacting the regulations. So I was hoping maybe Stephanie can talk a little bit about, how do you deal with this uncertainty, this new humongous way in which we collect data, these old frameworks that, they don't quite fit with some of the new technology, and then these new initiatives that just pop up, randomly apparently, and you have to deal with them.
Uncertainty is just a theme, and I would say that a few years ago it was applying existing laws to new technology, and now it's applying the existing laws plus new laws. And as you mentioned, CCPA, the regulations haven't even been finalized, even though enforcement will apparently happen on July 1st, and it went into effect on January 1st. So there's incredible uncertainty there. There's also a new ballot initiative that's in the process of gathering signatures, which will amend CCPA as well. So when you are counseling in a company and you have engineering teams and product teams asking you, okay, I'm reading about this, I know it's a big deal, I believe you that privacy matters, what do I build? It's a huge challenge, and you're also trying to help them, guide them so they can make decisions about resources and how to allocate them in the company. And is it to comply with the letter of this law that we don't even have the letter down yet, let alone what the contours of that mean, versus putting the resources towards something else. For example, for us, safety on the platform, and so you're trying to help them make those trade-offs, and it's really challenging. It's also challenging, I think we're going to talk about this a little bit later, when you're a global company and you're trying to balance all the regulations at once, and so do you, to what extent do you try to comply with that black letter law versus taking a principles-based approach? with CCPA in particular, one of the examples of confusion is around the definition of sale. So sale is a very broad definition under CCPA. It probably, if you read the definition, it would not match what you may think of as a sale. So it pulls in a lot of transactions that happen that one wouldn't think of it as a sale. And if you do qualify as a sale and you don't have one of the exceptions, you now have to potentially spend a lot of effort to build these internal systems. And so it's one word in the legislation that really can change how companies are having to spend their resources.
Right, thank you so much. And trying to figure out the future is difficult with technology, but with CCPA, I think trying to figure out the future of the regulations and the new ballot proposal that you mentioned is also difficult. So I was hoping maybe Andy and Michael could help us think about what to anticipate in terms of the regs that are not final, and in terms of whether this ballot proposal is going to pass, is not going to pass. What should we expect?
So I think, it's an amazing story when you look at how Alistair McTaggart got CCPA passed. And to spend only about $9 million and create a law that is sort of a mini accountability framework like you have in Europe is very impressive. And CCPA 2.0 is gathering steam, and again, it proposes some pretty rational things. I mean, I agree the definition of sale is very broad, any exchange of value. But it'll create a new tier of sensitive information around location information, biometric information, financial information. And so I should take a step back and just introduce my perspective on this. And so I believe privacy is a fundamental human right. And in past lives, I was the chief privacy officer of Amex, and I also founded Privacy.com, which is a company that nobody's heard of, but is an amazing app that lets you pay for things anonymously and securely. And I built it because I think ultimately GDPR is really the floor. It's not the ceiling. And I think that's a surprise to people outside of privacy. And so directionally, these things are going to keep coming. They're going to sweep in AI and algorithmic accountability. And ultimately, it's about making sure that companies are acting in a responsible, accountable way. But I think it's actually the innovation that's driving the regulation. It's the technology is moving so quickly, and the regulation is really catching up. And many technology companies who in the past were concerned about having regulation are now saying, like, let's have rational framework, because these are very important issues. So I think directionally we should not see this as like, this is a finishing point, or we're catching up to GDPR. Because as you pointed out, the definition of sale being so broad, CCPA is already higher than GDPR, in a way.
I was going to say, before we go to the next question, that I don't know if you know, but for Valentine's Day, Representative Chow, who is fairly powerful in Sacramento, introduced bills to deal precisely with AI and algorithm accountability. I don't know to what degree they will find the support to be enacted, but clearly what you were pointing out is happening right now. Like, we can see the movement towards more regulation.
Yeah, just to go further about where this regulation might be and the statute may ultimately be going. I'm new to California, been here 2 years. I don't quite understand the ballot initiative. I'm sure you didn't pick up on my accent, that I'm from somewhere other than California. But so this ballot initiative is going to come around again this fall, is the hope of Mr. McTaggart. And where that stands presently is the text of the ballot initiative has been finalized and applied for. He's seeking to secure necessary signatures to get that ballot initiative on in front of the voters. My expectation is that he will certainly do that, and it will be on the ballot. Some of the things to think about are, the thing that matters to me the most is it has this provision in it that makes it almost impossible to modify except through another ballot initiative. So it fixes in time for some substantial amount of time until Mr. McTaggart gets another scratch or itch that he needs to scratch. The law as it will be, which puts a lot of pressure on the AG to keep the regulations current, which puts a lot of pressure on folks who are trying to apply new technologies to a law that will be aging over time. So that to me is a problematic aspect of the new CCPA. And as Andy mentioned, it's going to introduce a new category of sensitive personal information worthy of higher protections, which I think most people think is a wise thing to do. It's not unlike what's happening with GDPR. A lot of the statutes that are being proposed in Washington are starting to think about data in terms of appropriate levels of protection based on risks attendant to that data being misused. So that's a step in the right direction, I think. Some other things it does is borrow from some concepts, again, from GDPR, like purpose limitation, making sure that data is used only for the original purpose for which it was collected, unless there's some other interaction with the consumer to authorize that. Data minimization, only keep that data which is necessary to do the processing that you told consumers you were going to do, and some other things in that regard. There's some language around profiling activities and the need to, if your profiling activities reach certain categories of processing, you need to explain how it is you're doing that profiling. What is the logic that is powering the decisions being made in that automatic profiling or decision making, which is going to lead to some interesting disclosures, I'm sure. And then there's this new context, or new concept of something called cross-context behavioral advertising, which is sort of what the whole sale concept was after in the first instance, but really missed. And this is the notion that if people want to opt out of targeted advertising based on activity that is observed across multiple properties on the web or applications, then they ought to be able to opt out of it everywhere. And so that's going to be in the law. And that will take some of the pressure off of this definition of sale in certain contexts. At least that's the hope.
Thank you so much. And Robin, I saved the easiest question for us. How do you learn all of that? What's the learning curve? And not only for organizations that have the luxury to have any of you as their chief privacy officer or the person responsible. We are seeing at the law firm a lot of clients that are just fairly national, like they never really were exposed to maybe GDPR in the way that the organizations you represented are. How can we get there? What's this journey we're making?
So when you ask me a question, it kind of makes me think about how I got into privacy, and I was kind of shifting careers, and I literally fell into it. Back in 2008, I applied for a job at this company called Trusty, which is now TrustDark, the little green seal, and I had to do a Google search for privacy. And the only thing I found was the Beacon settlement with Facebook. Basically, that was kind of like the thing that popped up at the top. Now, fast forward 10 years later, the GDPR went effective 2018. That was actually a really exciting time in privacy because, after you'd been in for a while, it was like, finally we have, something that's like a framework and some teeth. Because before that you had, the Fair Information Privacy Principles, which are from the government. You had the OECD principles. You had kind of frameworks to follow and programs, but you really didn't have one kind of enforcing law. There was the sectoral laws in the US. So now it's CCPA. GDPR went live, everyone tried to comply with GDPR and do it right, or some people said they tried not to comply with it and said, let's just get out of the EU. And then, 6 months later, CCPA, everyone had to scramble and comply. So when you say how steep is the learning curve as a privacy professional or someone who's passionate about it, there are definitely a lot of resources to dive into it and learn and keep yourself educated, which is actually really exciting as someone who's passionate about the space.
Okay, so that gives me hope. We will get there. Let's change a little bit and talk about just a little bit specific technologies, these new developments. And yes, everything is old in the Bay Area. It's 1 year old, but artificial intelligence has been a big topic, right? And it's a new way of using those, we're talking about, Joseph was talking about how much data we're recording now. How do you use data that you really, you couldn't see? A human brain is not able to process it. So we have this new development, and the legal frameworks are not necessarily designed with artificial intelligence in mind. And some of the things that we talked about, like purpose limitation, or knowing in advance how you're going to use the data, those concepts kind of break down a little bit when you think about it in the context of artificial intelligence. So I was hoping we could talk a little bit about how the CCPA and just regulation in general is impacting this area. Maybe, Robin, you can take the lead, and then if some other panelists want to jump in.
Sure, so Twilio is kind of in a different space than a lot of these companies because we actually act as a processor. And if you're not in the privacy space, I'll just give you a quick overview of what that is. So if you take an Uber, right? Most people take Uber or Lyft, and you text with the driver, and you know how you don't see their phone number? That is a Twilio technology. We're powering that. And we are acting as a processor, which means we are processing the data on behalf of Uber, who is the controller of that data. So in the AI space, it's actually really interesting because you have to really be careful around what you do with the data in the AI space, because it could blur the line between a controller and processor. So peers in that space, in our space, in the SaaS space, we're trying to look at the right way to do it to make sure that we're putting the right contractual terms in place, or really thinking about the right way to do it both for GDPR and CCPA. So some frameworks include the ICO guidelines on AI. There's definitely a lot more frameworks coming out that you can now start to read up and follow on.
All right, so how can we make sure that these decisions that are made through artificial intelligence are fair, right? Like that's the big topic. Do you guys want to take on that? How do you deal with that? Accountability.
So there's a couple things that are interesting about an AI system. Usually when the engineers are feeding the AI system, they're trying to get a large data set that they can use to do what they call training, which is when they're building the system. And then the result of the system they use for the inference step, making the decision that you're describing. Often the engineers who built the system will not understand the inference step. So as a simple example, the people who train AlphaGo to play chess don't play chess as well as AlphaGo. They can't explain its moves. They could try to explain one move by a very tedious process of taking apart the system, but that would take years just to explain that one move. So it's very hard to give someone a human language explanation of what the system is doing. There are a few companies that are, I think, kind of ahead in this area. So for example, Stripe does payment processing. If they refuse a credit card, you can ask their API, why was that refusal happening? And the refusal is powered by AI systems, so the AI system has to know how to generate a written explanation, like in English or Spanish or whatever. So I think you'll see a lot of these AI systems in the future will have this feature built into them, and that way the user can ask for an explanation and get it as a second step. There's a very primitive version of this on Facebook ads where you can ask why you saw an ad. And I think you guys touched on this earlier. I expect people will think that's a natural thing, that they can ask for an explanation. So why was this recommendation made, and specifically why was it made to me? Like what characteristics about me led to this item being recommended? You can imagine like your Netflix movie selections, recommendations. So that'll be a feature. It's in the GDPR, but it sounds like it's still coming in the CCPA. So I think that'll be common. And then another thing you would worry about is that the data that went into the training process, was it public or private? As an example, Facebook might train a face recognition system on people's faces from photos that they posted on Facebook. Then if later on you decide that that photo of your child is now private, you have to remove it from the data set and retrain that AI system, which takes a long time. So now the company has to worry about, will these images remain public or become private? And then the last thing I would say here is that a really large company that has a huge amount of resources, both people and compute power, they can probably get away with adding explanations or retraining their system when they need to. But a smaller or medium-sized company that can't afford that, they're really at a disadvantage in this situation. So the way I sort of think about it is, these new privacy regulations kind of raise the bar, and the bigger companies are at an advantage.
Right.
I respectfully disagree. And so I think that's a common belief that a lot of people have, that GDPR actually favors the larger tech companies. Again, viewing privacy as a fundamental right, or the way Europe just released their white paper on AI and another accountability framework. We'll step into a vacuum where it will be viewed as rational and probably be a template for a lot of things. What you did talk about with explainability, so with algorithms and AI, specifically ML, people have been very focused on two buckets. One, which is unexplainable, and one is explainable. And I'm not here speaking on behalf of my company, but I think that going into Congress and talking about unexplainable algorithms, even if they're for vanilla uses, will result in a lot of problems. And so I think that people will have to focus on increased observability in the models, and they're going to have to really focus on the creation or amplification of unfair bias or discrimination, which leads to the most complex problem, which is you have these effects on protected classes, on genders, when that's not the data that goes in and it's not the data that goes out. And in addition, the last thing that, again, I'm super nerdy in this area, is that we have systemic bias in our society. So at the end of the day, a lot of these models will reflect that to a certain extent.
Right, that's interesting.
So I think that, so the last thing I'll say is I urge people to consider processes that they can put in place to validate these models, to test them, to show that they're secure, and I think that's very much in line with what Europe is thinking.
So before we continue the conversation, I have to say something that I promised I was going to say and I neglected to say at the beginning, which is nothing that I can say here is a legal opinion, and it's not to be quoted back to legal, especially in a court of law. And everybody here is speaking on their own behalf and not on behalf of the organizations that they represent. Currently, they have, all of them, they have a long experience in privacy, and they have, seen this from the perspective of different organizations. So, then, let's move on to personalization. And this is something that I think connects with artificial intelligence, but it's a very hot topic, this idea of personalizing advertisements and how this has been done for years. There's arguments to be made that it's a more efficient way of presenting information to the user. If you can identify somebody who has an interest in diapers, they might be more willing to buy your product than if you send that out to somebody who maybe doesn't have a child. So there's incredible pressure on both the EU side and I think on the CCPA side as well, based on some of the comments that we have heard from the AG on changing some of the default ways in which we are personalizing ads. And since Joseph was kind enough to take on the AI question, and I think that your opinion was, respectfully disagree with. Let's give you a chance. Would you help us understand a little bit how these regulations are impacting that space and what we should expect and how organizations should think about compliance?
So you're asking specifically about advertising?
Well, personalization is much bigger topic than advertisement, so take it wherever you want to lead it.
Sure. So I think a lot of these regulations came out of people's fear that a profile was being built about them and then it would be applied in areas where they didn't expect it to be applied. That someone else would just know a lot about them and be able to manipulate their behavior without them being aware of it. That's kind of the biggest fear. My personal feeling is that might be exaggerated, but I definitely agree that it's the fear. And there's no doubt that huge amounts of information are being collected about people. And often, like this concept of purpose use was mentioned, it's often used in a way that it wasn't originally requested to be used. And that's a clear violation of the GDPR. So what you'll see inside of a larger company, for example, is that one product will collect some information for something, and then it will be used by a second product. And when the user finds out that that information was used in that second way, they're really surprised. And they feel like they were sort of tricked into something or cheated somehow. And often this can be done purely by accident. You can imagine that large companies collect large amounts of data and they use it to do analytics, and then they end up doing the wrong thing with it. So tracking exactly why each piece of data was collected, what the purpose that you originally specified was, and then tracking that all your code is executing under some purpose and making sure that the purpose of the code execution matches the purpose the data was collected for is really hard. And the engineering tools don't fully support it yet. But I think that's a big area of development.
That is interesting. I think that we hear a lot that answer from engineers and technologists when we say, well, the law says we're supposed to. How do you code that? You know, how do you make it happen? And moving to a different topic that is also been a hot topic in terms of new technology for a while. The idea of blockchains and decentralized systems has been very active, and there's different ways in which this technology has been used. It becomes a little challenging because really when the European framework was built, they were not thinking about anything decentralized. They actually were thinking about a centralized model for computing, and so some of the concepts that the panelists have introduced, like the processor and controller, when you try to apply them in a blockchain, it becomes difficult. Or the idea of you have to erase data at some point. If the data is in the blockchain, that might not be as easy as you think. In fact, you might be told that it's impossible. So how do we think about blockchain and compliance? And it does also have a lot of potential for privacy at the same time. Like you can build privacy-enhancing technologies on blockchain. So Andy, can you help us understand how to deal with blockchain and compliance?
Sure. So I was attracted to blockchain very early because of the privacy protective features, and I was counsel to the Bitcoin Foundation. And when I founded my startup, fintech startup, privacy.com, I founded it with a couple kids that were running a Dogecoin exchange. And for those of you who don't know what Doge is, it made me rethink the validity of Doge, but Doge at the time was used as a fractional currency to incentivize online behavior. And I got involved, like a lot of people, because they thought, well, this is going to be like internet money, and it's going to really protect civil liberties. And then there's this irony in decentralized technology that they ultimately require some level of centralized governance. And there's a lot of misperceptions about what blockchains do and what they don't do. For instance, Bitcoin is the least anonymous money, right? I mean, you can trace the whole lineage through of every transaction. And so I think there's tremendous promise. I think crypto is losing steam now. And so just when everybody starts to hate it, that's when it will rise again. And it does have a lot of promise, but to me what it signaled was, I believe that privacy is not a compliance effort, but I actually believe that privacy is a product. That's why I built privacy.com. And so just like people eventually wanted salads and McDonald's sold salads and electric cars became profitable, at some point privacy will become profitable, like diet soda, anything else, and people will want versions of products that are privacy protective. I think that the Bitcoin is really in a different category from the rest of decentralized technology because it protects people from sovereign governments taking their money away. But I think that there still is a lot of promise in decentralized technology, but ultimately you come to this paradox that there requires even just decisions whether to fork the protocol requires centralized decision making.
Right. And I think there was a little bit of criticism of Libra when Facebook came out with the idea in terms of, it might be too centralized to be really whole blockchain.
I think the way the industry has developed with this Genesis story, you know, with a mysterious person, and it's like, and then I was at law firm Cooley before, and we were, my partner Marco and I were doing a lot of the work that was leading the space, and then the creation of these foundations and these like corporate constructs and organizational constructs that arose. Ultimately, there is something with decentralized mesh networks that are really resilient, that have a lot of power for good. And again, I don't really buy that you can't apply traditional accountability frameworks to decentralized technologies, because I think you can. And so I think that governance is just, in anything you want to do, it's something that you have to address now.
Thank you so much. I like it when we have this positive, approach to compliance. So we were going to move on to another topic, which is a little older for Silicon Valley standards, I guess. But not everybody's in the cloud yet, right? And there's this movement that has happened over time where, it's more efficient to do a lot of things in the cloud. And that's from my notes that I use for the class, approach on Mark saying whatever it is, I'm against it. That's what we face sometimes when we're trying to preach data protection and preach privacy. But I think there was a resistance in many different ways to the idea of the cloud. Not only privacy, data protection, security concerns. There was a number of points that were contentious. So I was going to ask maybe if Michael and Stephanie could help us understand, where we are in terms of cloud adoption and compliance, and whether CCPA is going to impact this in any meaningful way or not, which is, I think, part of the theme that we have to do in the conversation.
So I'll echo your concern back in the old days when cloud adoption was first being considered by large companies. I used to work for a broadcasting company who had multiple cable networks that had to be up 24 hours a day, and they couldn't afford to have any downtime. So they were scared to death to put any of their assets in the cloud, and so they spent ungodly sums of money building infrastructure that is now just sitting in not very productive uses. So cloud has become something that is commonplace, that the efficiency and compute power you gain by utilizing the cloud is just is hard to beat. And if you start peeling the onion a little bit of your organization about how they are using the cloud, they're probably using it in many more ways than you even know. And CCPA is interesting because it forces you to focus on every data sharing relationship you have across your entire enterprise. And once you start looking at it from that lens, you start realizing that yes, there are tons of small providers, large providers, gigantic providers with whom you're sharing data. You have to analyze that sharing transaction, you have to understand its purpose, and then you have to evaluate whether the contractual protections in place between you and the counterparty are sufficient to satisfy each of your obligations under CCPA, particularly as it relates to the notion of whether you're keeping that data secure enough if personal data is involved, and the consequences of making a bad judgment on that can be catastrophic under the new statute, because you can open yourself up to private rights of action and to serious penalties from the Attorney General. So it forces you to really think about what is it I'm sharing, with whom, what is the contractual relationship with that party, and then do I have in place the appropriate security provisions within that agreement to make sure that we both can share that data securely.
Thank you. And I was going to ask you to also help us understand in the cloud this idea of data localization. Is like an old thing that every privacy professional, I think, wishes it will go away because it makes less and less sense sometimes. Argue that for some, very sensitive government data, etc., it should, but we have Russia requiring data localization. There's some comments about whether India will require it, and how do we account for the cloud and localization and all of these requirements in terms of compliance?
So I would echo what Michael said. I think when you're thinking about data localization, you need to know where your data is, where your customers are, but also what can your vendor provide, where are they storing the data. Some vendors who are large offer you choices of, are you going to have it in the general cloud, often in the US, or do you need it localized in different parts of the world? Sometimes you need that for performance anyway, but those are the types of things that you need to think through. And there are, Russia as an example, also India, are demanding that you localize data there. And as a company, you need to think through your business model, your principles, and what matters to you as a company in protecting privacy rights when you're balancing it against government saying that you have to localize the data there. How is it going to impact the people who use your service too?
Thank you, that is really helpful. And I think that from the perspective of the regulators, or at least the European perspective, which is the one I'm more familiar with, initially the idea of keeping the data in Europe came from, well, if it leaves Europe, how do we know that they will follow our requirements, right? So there's different frameworks that have been created to kind of deal with that question, while enabling some flexibility in terms of the location of the data. But then there's other situations like the one you were mentioning where, there would be governments, we're not going to name names, but that they might have an interest in actually having physical access to a server that stores data because that secures their ability to get access. Where if it was not physically located in their jurisdiction, they might not have the same ability. So there's a lot of internal questions in terms of your values as an organization and how do you deal with compliance. We're going to talk about solutions now, right? Like, these are all the challenges. Let's move on to the solutions. So let's talk about how there's different ways of approaching regulation, right? Like there's the idea of self-regulation, which was very prominent at some point. I think right now, there's a more of a tendency of just give us the rules, right? Like we just don't want to necessarily create them ourselves, although there are models that were very successful, like PCI DSS, self-regulatory regime that has, by all accounts, been very successful. There is the idea of, for example, we were talking about the Europeans and GDPR and this overarching law that is, in a way, an equal opportunity offender. It regulates data in the public sector, it regulates data in the private sector, but it does give you some structure, and I think we talked about that a little bit, right? Like, finally, there is this cohesive way of talking about how we regulate privacy that we can kind of build on. And then the US model traditionally was this, well, there's no problem with privacy, there's no problem with technology, and when we find the problem, we'll solve for that specific situation, which led to, fragmented sectorial approach to imposing rules. And then I think CCPA is kind of trying to cover basically everything that's not covered by other laws now, which is why I think it's being fairly impactful in terms of the reaction of the industry. So how should we approach regulating data? And Stephanie, you volunteered to give us the initial answer.
So a 50-state system, 50 plus, and you're dealing with international laws is really untenable for companies. I think when you're trying to counsel your clients, when you add complexity, when you're building systems and coding, you are increasing the likelihood of bugs and that there will be a problem from just a technical standpoint. But for companies too, are you going to have different compliance systems for California, for Nevada, for your EU participants? It doesn't really reflect how companies operate and how people operate. People move, they get on airplanes, they cross borders. And so how can you, we have been supportive for several years of the federal privacy bill. I think, as Joseph pointed out, many companies now are begging for one. because it is causing a lot of churn for companies of how do you comply and what are the expectations, and even for consumers. They're not sure what are my rights, how do I contact companies. Companies, in addition, when they're dealing with compliance, are told, make your privacy policies really simple. But then we're also told, you need to include all these very specific things for my specific state or country in your privacy policy. It really becomes untenable for consumers to understand what's going on. And if you are a mobile application, you're trying to do that in a very small screen. So again, having a single GDPR was very helpful as a start, and then having federal legislation would be additionally helpful. Right now, because you do have GDPR, you have countries like Brazil following in GDPR's footsteps. Japan's getting an equivalency ruling. So the US could take a similar GDPR approach or come up with a different American approach to privacy, because we have taken a different stance as a country philosophically. But if we don't have a federal privacy bill, then I think by default we will end up in a world that's looking more GDPR-like.
Right, and to give a little bit of background on this, after CCPA was approved, there were an increased number of bills that were proposed at the state level. There's always a lot of bills proposed at the state level. Most of them fail. But last year it was fairly significant, the increase in the number of bills, and also the increase in, I think, the approach to regulating. You know, there's a number of bills that were very similar to CCPA, more expansive than what we have seen at the state level. The question is, will we see federal law, right? And it seems like, let's ask the whole panel, do you guys will support the federal law for privacy as opposed to the state approach? I think that we have a unanimous yes here, right? So, and it reminds me of 1995 when we got the directive in Europe, because the reason we got a directive in Europe is because every country was regulating in a different way. Like the first Spanish law was from 1992 and included a right to an explanation for decisions that were made by computers that went away with the 1995 directive. So it was that pressure of having different states, different member states regulating different ways that actually led to the European Union moving. So I think that we've seen a little bit of that here. There's another component to the role, which is how do we enforce that, right? Like when we're talking about approaches to enforcement, and I think that we have fairly closely embraced GDPR. The privacy community has embraced this idea of having something that is structured in a way that is comprehensive, but at the same time we haven't seen an enforcement under GDPR. And I wonder, if the attitudes might change depending on, what is the next move of the CNIL or the Spanish Data Protection Authority or the Italian Data Protection Authority in terms of enforcement, because the powers that are given to these data protection authorities are quite remarkable. So what's the best approach to enforcement, Andy? How do we strike a balance there?
So first of all, I'll take just one step back and say, I think that if you're a company, you can keep trying to operate at there's a mindset, we do the lowest in this market. I've always been against this because I treat privacy as an operational risk and a business process risk. And anytime you increase operational complexity or differences, you lose anything you might gain. And so I don't speak for my company, but there are many companies who say, you know what, we should give these data subject access rights, not just to California residents, but to all US residents. And that's where things are going. And so we should build those capabilities. From an enforcement standpoint, Europe had the directive, then it had the regulation. And so treating privacy as a fundamental right set them up with the accountability framework. But then they fall very short on enforcement. Enforcement is not, coming out of some very important places like Ireland, very little enforcement. Part of that is they need to be prepared to defend anything they bring at the appellate level. But I think what will change in Europe is the confluence of competition and antitrust law and data protection law. And so when they introduced the fines for GDPR, it was up to 4% of worldwide turnover, which is completely consistent with what competition law is.
That's exactly where they took them from. I mean,
And so Vestager,
where
who was in charge of competition, is now in charge of digital.
Yeah.
And what's been holding us back in the US is, again, we don't define antitrust harm as manipulation of data. But I think what's going to change, that is going to be a tipping point in Europe, is when the two worlds come together of data protection and antitrust regulation, and they bring some cases against some very big companies. And so I think we'll see enforcement change. In the US, there's a private right of action. It's limited currently to a breach as defined by CCPA, but certainly firing up the class action bar is, it will change things, it will motivate people. But again, I think that many companies, certainly companies in the Bay Area, understand consumers want greater control. In order to provide that, you need to be building capabilities. It's not just policy. You need to have a new architecture that contemplates, as Joe said, being able to do these things, to put these, fine access controls in. And I think that the days of treating privacy as like dark patterns and hide the ball is over. Now it's actually, let's understand how people want to engage with us, and then let's optimize for that. And that will actually be the most valuable thing.
Right, and just to give a little bit of context, because not all of the audience comes from the legal side, this idea of class action lawsuits and how they play in the US is quite different from what we have seen traditionally in Europe. In Europe, you tend to see enforcement through agencies, data protection agencies. Here we have certain laws, specific laws that provide for a right of action at the private plaintiff level, and this lead to litigation where there's law firms that are, their business is to identify these laws and sue a company that has deep pockets and settle for millions. I mean, there's a rumor, can we talk about the Facebook biometric thing? So there's a rumor that BIPA, one of the state biometric laws, is going to lead to settlement of, I think they're saying $556 million. I mean, they can lead to incredible settlements in terms of the amount of money the plaintiff's bar gets kind of paid out of the settlement. And so it's kind of privatized enforcement, right? And I think that what I heard from Andy is that we do need a stick, but we need to be kind of smart with who we give the stick to and how that stick applies, right?
I think companies should be smart with data also, but yes, I agree. It's a balance on both sides. I think California recognized that they don't really have the resources to enforce CCPA, and so they carved out a piece for class action litigation. That one is challenging just in the world of class actions. When you're in a new space, if somebody capitulates first, they essentially fund the class action bar to then go sue everybody else.
Right.
And so we will be seeing many more biometric privacy cases for sure.
Right. There's hundreds filed, so yes. So, okay, so talking about Andy's point about how to be smart, how the organization is smart about compliance, Robin. How do you build a program? I mean, there's all these different laws that have different requirements. Some talk about you shall not sell, some talk about you shall have a lawful basis. I mean, there's all of this language that I love, but most of the people who actually have to code this don't want to have anything to do with. And how do we translate this into a program that can funnel the law into actual code?
So Twilio has, and I'm definitely a privacy dork, we have what are called binding corporate rules, and it's a global framework for privacy. So in agreement with Andy, it's kind of difficult for an organization to say, I'm just going to do GDPR for EU citizens and then CCPA for California residents. And I am starting to now see companies thinking about, let's just do this globally, let's do this right, because they see what's coming down the pipe. But the great thing is that the organization I do work for, we do have binding corporate rules and we implement our privacy practices globally, so we can build a global framework. So we have policies and procedures that can be approached globally, which is much easier to enforce and scalable.
Right, and to give a little bit of context on the idea of binding corporate rules, it kind of ties with that slide that I had with whatever the cloud is, I oppose it. So the idea was at some point that, when I started doing data protection law in Spain, and we had to export data, we actually had to print the contract and go to the Data Protection Authority and get them to say, okay, this is good. That was a bad system. And at some point, the Data Protection Authorities didn't like it because it was a lot of resources. So the whole idea of you can export data, but that organization can still be responsible for the data when they are moving it internally. You give them freedom to move it, but at the same time, the organization is making this commitment that they're going to follow all of these principles, and they're going to build a program, they're going to audit a program that follows all of these principles. Kind of gives the European Data Protection Authorities the peace of mind that they can be more relaxed about where the European data goes, knowing that the organization is going to basically treat the data according to the law, even if the data is outside of the jurisdiction of that Data Protection Authority. So when we think about that idea, right, like we want to build a program, these laws might not be identical. I think it's unreasonable to expect that they will ever be identical. I don't see how, GDPR will literally be unconstitutional if enacted in the US, so we have to find a different way. But can we make these things compatible? I think that's a more realistic conversation, right? Like these laws might be different, but then when you kind of align one with the other, you can with a set of requirements that are compatible with each other. So maybe we can talk about the frameworks and how they can be a path to compliance, and how there are different ways in which NIST is trying to develop right now a framework. There's different initiatives, Michael. Well, is it good? Is it a bad thing? How do we wisely think about this?
I think the more tools you have available to you to implement some of these notions of privacy and data protection, the better. To me, the best thing about GDPR was it enabled privacy practitioners in the United States who long for some reason to get their companies to act in a different way as relates to data protection and privacy generally. It gave us this new way of thinking of it as no longer a point-in-time compliance obligation, but as a mindset and an approach to how you operate your business. And so GDPR loosely sets up a framework by which you can start thinking about privacy in that way, with concepts like privacy by design, for example, and privacy assessments and justifications for each of your processing operations. But not everybody has a language available to them or experience in their particular organizations to do that, to have a standardized way to think about continuous improvement, measurement, accountability, and what it is you're going to keep doing or look at on a regular basis to determine how you are progressing up that curve. And some of these frameworks for privacy or for cybersecurity, for example, they look in operation very much like an auditor's approach to financial security. It gives you a set of controls you can look at and identify as relevant to your business, and then measure your progress against them. Identify your current state versus an end state you aspire to, and give you a way to think about how to build a roadmap to get to that more desired state. So I think frameworks are helpful. Ultimately, you have to discern a set of principles that you are going to adhere to, because it's impossible to keep abreast of all these laws and the proliferation of state laws and national laws around the world. It makes it very difficult, and you try to build the highest common denominator through a set of principles. Perhaps a framework can help you do that. So yeah, I think frameworks are helpful, but it just gets you part of the way there, but it's a good step.
Thank you so much for that answer. And I'm afraid that frameworks are useful, but we have come to this point where they're not enough. We need what we're now calling privacy tech. Like, how the hell do we find the data, right? Like, we need to make technology work in a way that enables the controls to actually be operational. So, Joseph, you're talking about how, how much data we have and, all of these technical challenges. What do you see coming from this new hot thing of, privacy tech? And I believe the Hive mentioned that one of their startups was a privacy tech startup, which is great. But it seems to be a growing area. There are promises that are made. There, to some degree, sometimes organizations that promise some functionality might not completely be able to provide it right now. But there's a journey towards finding technology as a solution to technology, basically.
Yeah, so I can imagine, like, if you're trying to run a medium-sized company and you haven't really thought out the privacy regulations yet, then your immediate questions are, what kind of data do we have? Which part of that data is what amount of risk to our company? So, like, which data is dangerous to us, essentially? Which data is justified by the business process that's associated with our business? So it's totally reasonable for us to have it and use it. And which data we collected for some other purpose and now it's bad, we need to get rid of it. Also, if we have multiple products, are we sharing data between them? Because that means that potentially we told somebody we'd use it one way and then we use it a different way. Are we keeping the data too long, or are we ever transforming the data in a way where we lose track of it? It's very common for people to have data in analytics systems, for example, where they're just trying to figure out how to improve their product, and then they realize in the middle of it that, oh, some of this data is private, it shouldn't even be here, how did we get here? So being able to track what kind of data it is, where it's going in the company, how much of it you have, and how risky it is, I can imagine a whole swath of the economy is probably thinking about that right now and considering what they would install and what kind of view would give them and what actions it would take. I haven't actually seen companies that do that end-to-end yet, but that's imaginable.
I think another area is, how do you have tech that actually can prevent code being pushed that is going to violate some of those rules? So a lot of the tech now is a layer which is trying to define what data do you have, where is it going, but how do you also have tech that will help engineers and help developers follow the rules that you actually put into place so that they, kind of tech for dummies, so that you can't break the promises that you've made, and tech that can actually capture what promises you have made on a go-forward basis, so you don't find yourself in a position where you're having to clean everything up at the end.
Yeah, I think you described it really well. I mean, you have to know exactly which data is good or bad, what purpose it's going to be used for, or what purpose you told someone to be used for. You have to tag all your code so you know what purpose any given piece of the source code is executing under, which is really tricky because sometimes code modules are shared between systems. And then you have to at least do analysis at runtime to make sure you're allowed to take the step you're about to take. And there are some systems that try to do so-called static analysis on the code before it's ever deployed. It's a little bit trickier, but it is doable. But it requires that all the data has been tagged in advance to even get underway.
I think that's actually a major issue that a lot of companies are facing right now, is how do you even annotate and register the data that you have? How are you finding all the places that it is in your systems? And that's a challenge, and you kind of need that as a basic step to do any of the additional compliance steps in an automated way.
Right, and I think we're coming kind of round circle to the beginning of the conversation where we're thinking, when organizations had less data, they were carefully curating the data, and now we have to figure out how we take these massive amounts of data and some way use technology to kind of curate them so that we know what we can use them for and what we cannot use them for. And even to the beginning of the conversation when we heard the story about, the person who came to California and found gold, and at the end, it just didn't work for him, right? So now, how good is the gold that we have been storing if we don't know if we can use it legally or not, right? So that is the end of the conversation, but before we finish and we move to questions, I would love for our panelists to give us some tips. You know, if you want to give maybe one tip or a couple of tips that this audience can take with them in terms of, you know, how to be wiser about, you know, starting maybe a company that is small, maybe, you know, a middle-sized company, maybe they're working in a bigger organization. How do you think about compliance? And I'm going to give one before your turn goes, and it's figure out how you can erase the data if you need to, because all of these regulations seem to be requiring it. And I know that it's not as easy as it seems, but it's kind of encoded in the law, and if we cannot find it and erase it, we just not started at the right point. But Andy, do you want to start? Maybe we go around?
Sure, I was going to say that I'm lucky enough to work with other stakeholders, senior leadership, who take these issues very seriously. And they understand that they're not just legal regulatory issues, but our chief data scientists. There's tremendous buy-in from the top that these are things that we need to dedicate resources to, that they're really engineering issues. And a lot of what's been talked about, the immediate short-term opportunity in privacy tech is to work with the existing systems. But the direction that companies should be headed is, what are the architectural changes that I can make so that I engineer the privacy and governance requirements into my systems? And it's actually fundamentally a different architecture than we're using now. And so that's very challenging to get from here to there, but treating it as a compliance issue is not the right approach. It's a business issue. It's being responsive to changing customer requirements, changing partner requirements, where partners want to give you data to use for X but not for Y. And so these become table stakes for running a modern technology company. And they're issues that impact the entire organization. And so trying to approach it as a compliance obligation gives people the impression that it's like project-based and maybe we'll swarm it and put some people on it, but actually this is, as you mentioned, the frameworks are sustainable. And this is where things are going. And to me, it's very enjoyable because I've been in the space for 20 years. And so now, for the first time, VCs believe, well, some VCs were visionary, but some other VCs for the first time are looking at privacy tech and saying, there's real costs associated with this, so privacy tech is profitable. And I think the aha moment will be when consumer privacy tech is viewed as profitable, and then we'll start, just like we got salads and Diet Coke, I think we'll get privacy stuff. But the answer is, taking it outside of a compliance obligation, where it looks like it's a cost or it's somehow a limitation, and then understanding like this is something we need to do strategically. And again, I'm very lucky to join a company that has people who really believe in this.
So embedded into your DNA will be kind of a summary of, will it be fair to say?
I think actually, I've always believed that young people care more about privacy than older people. So when I built privacy.com, I focused on a young team and young early users. And I think employees at companies increasingly care about these issues. And they want to work for a company that stands for something. And so I think it's actually, every generation thinks the next generation is completely lost. But the older generation now is on social media, sharing pictures, and younger people really see it as control. And so I think these are big cultural shifts.
That's right.
And so treating it as a compliance thing or CCPA thing misses the bigger shift in strategic opportunity.
That's very interesting.
Yeah, I totally echo that. Focus on the culture. You need to develop a competency around this area, not a compliance mindset. I totally get that. And then, on a practical level, we've all said it multiple times, know where your data is, because that's the essential first step. A lot of people call that data mapping, but if you've actually seen a data map, it will send you screaming into the night. But you do have to know where your data is, and that's the starting point.
Right, and when you think about knowing how to find your data, there's different approaches, and I agree with you that, law firms, we usually start any compliance program with let's map the data. Those maps become obsolete fairly fast. And so if you don't have a solution to kind of continuate this and embed it in the business, it's kind of an exercise that might be needed for those purposes, but it's not that useful in the long run. How about, for example, mapping your systems, figuring out how systems connect to each other, like the pipes? How useful is that in your view?
Totally useful, yeah. None of that work will go wasted. The difficulty, the reason it doesn't answer the question fully is that individual users can use those systems and pull data from them and put it somewhere else. But you at least know the basic framework of how the data is supposed to flow throughout the organization.
One more question. I'm enjoying asking questions. So how about technology, right? Like there's privacy technology out there saying we can actually automate this and really map your systems. Some organizations have very complex ecosystems, and what's the benefit of actually investing on a provider, a service provider that can automate this to some degree?
I think your better investment is architecting a better mousetrap on the front end, so that you don't need somebody to come in and put a layer on top afterwards and identify where all the data goes. You built it from the ground up to make sure the data has only certain places it can go. It has certain controls about who can make it go otherwise. And I think architecture and infrastructure in the first instance is a better way to solve that.
Thank you so much. So we have the culture, and now we have the, figure out how to build your system so that your system knows where the data is, not necessarily go to your friendly law firm or, your service provider, but just structure it right. What other tips can we share with the audience?
So following on from the theme of knowing why you're collecting the data and then tagging the data when it comes in, there are systems that try to propagate those tags as the data is manipulated. You could think of it as lineage or provenance, depending on which direction you're going. So I guess the part that I would add, bless you, is always make sure that that metadata, that information about where this data came from and how you're allowed to use it, carries along with the data throughout the entire system. I like the idea of being able to rip and replace everything and build a better system. I'm all for that. But I think there's a lot of companies that are already staring at existing systems. And so for them, they end up having to augment them somehow or build a parallel metadata store. And that's, I think, where a lot of them will be stuck for the next, a decade or so.
Right, so to that good description of where the data came that is attached to the data itself. So wherever you find it, you can remember what the history of that data has been. And this is really interesting because, US privacy has always been consent-based. I think we're changing that. But the Europeans forever were purpose-centric. I mean, from their structure and perspective, it's all about the purposes. It's not really whether you got consent or not, but why did you get that consent? What was agreed and what's the purpose, and can you stake to that, right? So that's very interesting. Robin, what else can we share with this audience that can be helpful?
Well, I agree with all the panelists, definitely with kind of getting corporate buy-in from the top and really making sure you have the right culture around privacy in your organization and getting that tone from the top, because it's hard to go to an individual engineer or product manager and ask them to make this change, and they'll say, I have all these other things to do. So top buy-in is really important. But it's also, I think, your general company culture, having like values. One of our cultural values is no shenanigans, so it really is. It's actually on our website. And I might be talking to someone and they might want to do something and say, does that feel right for our customers? Or another one is wear the customer's shoes. So definitely a top-down approach, but also a cultural approach is trying to educate around privacy and doing the right thing, and around kind of data ethics as well, because that's, you know, also a little bit where this conversation is going on AI and privacy. It's, you know, what you can do with the data, but is that the right thing to do? And a lot of these AI frameworks also have a section around ethics, like, are you doing the right thing?
I love that. So we have the human element, right? Like technology is not going to solve for everything. We also need to think about how we change the mentality within the organization and make sure that people are looking at it from the right perspective. Do we have something else that we can share with the audience? I'm sure we do.
A couple quick things. The culture is exceptionally important. We have a program called Doves, which is voluntary at our company, and we have folks from all over the company. So we have engineers, marketing, HR, legal folks in there. And the motto is trust is earned, not given. So it goes to the ground up and the top down culture, along with the mindset shift. For me, engineers and product like to solve problems. And I think privacy and how we deal with these issues is a really challenging and interesting problem to solve, and there will be innovative solutions. So if it can shift the mindset, if we can shift the mindset from it's a compliance, tick the box, okay, I annotated the data and we're at whatever percentage, to, wow, this is a really hard, challenging problem and it matters to people and the consumers who are using our services. And I want to be someone who's solving that and finding innovative, elegant solutions to it. Can go a long way. My practical tip is documentation, which is required more under GDPR, but I try to sell it to the business as actually it will help you in the business understand why we built something or where the data is going if we document it. So it's not just a compliance function, but how do you marry those so it's actually effective documentation and not just a compliance task that you have to do. So that's my practical tip.
I love that tip. I share it with clients often, right? Two things. One, we're talking about this when we met earlier, that people don't stick around for long in companies these days, at least in the Silicon Valley. And if you have not created a way to kind of transfer knowledge, then you don't have the knowledge when the person leaves. So that means you have to figure out a way to document. And the last thing that I wanted to say is this has been a fantastic panel. Thank you so much for answering my questions. Now you're going to have to face the audience. And I'm sure there are some hands coming up already.
We're only going to have time for a couple of questions, so first hand.
Yeah, thank you very much for providing these very interesting insights. My name is Justin, and I wanted to ask a question to Andy. I loved your optimism and the way your perception of privacy and the fact that it should be a fundamental human right. Now, since you are in the financial space, I wanted to ask you your opinion on CCPA and the fact that GLBA, so a lot of the financial sector is kind of carved out. I know that your perception is that the law should be the floor, not the ceiling, but especially I've heard recently, like banks, they sell personal data left and right, like individual transactions. What do you think will be the driver for financial institutions to actually become, and I'm more talking about like banks, but I guess you're like closest with like TurboTax and also I think.
So I won't speak on behalf of my employer, but I'll say that you pinpointed something very interesting, which is McTaggart, when he was going to get this ballot initiative passed, which nobody expected would possibly pass, because the banking lobby would shut it down. And so he created a carve-out for banking, and it passed. And so building a fintech company years ago, many startups said, I want to avoid regulation. I want to be a software provider adjacent to regulated entities, but I don't necessarily want to embrace regulation. All of a sudden, GLBA looks really attractive because there is a broad-based exemption in CCPA, and every new law that gets proposed copies that same exemption. And so I think it's going to lead to more companies embracing GLBA because it's a sword and a shield. I am a super privacy wonk, obviously, but it actually becomes an attractive framework. And then as for banks selling data, I don't really think banks are selling data. I think there are a lot of misperceptions, and what's going to happen is increased scrutiny in general over financial transactions and fintech and open banking, data portability, and ultimately probably a couple of years before people realize that GLBA probably needs to be heightened, because in some ways it may be lagging behind the other consumer privacy laws. But yeah, very interesting interplay between, and it's really a fact that McTaggart was very smart and knew that to get this passed, he could just take out that group. And then now every new law has a GLBA exemption, including the ones at the federal level.
I'm going to add one thing to that not a lot of people know. The other thing that's exempted is the non-for-profits, because they will not get the ballot approved if the non-for-profits were regulated at the level that companies that operate for profit are. So yes, it's part of the history.
Hi, thank you for a very interesting panel and so much to think about. I noticed in the first slides when you were discussing what these rules are going to be, what we can do and how we can opt out. I have not seen that. I have not seen any website that I've been traveling around that offers me the opt-out. And I'm wondering, is that just Europe, or did we just not, am I missing something?
I think it's a really good question for the panel, because when CCPA was enacted, the idea was, oh my God, everything is a sale. So everybody's going to have to say, here's your right to opt out of sales. But I think that we ended up in a different place where many organizations maybe took the position that they were not selling or adjusted the behavior so that they will not be engaging in activities that could be considered sell. And by and large, I think most organizations right now are taking the position that they do not sell data under CCPA. And I'm sure that you have gone through that journey, right? Like not only you with the organization that you're representing, but probably having conversations with other professionals that were trying to also figure out, where this concept of sell, what does it include and what does it exclude? So could you talk to us about how that conversation went and where we are and where we might be in a few months once we start seeing enforcement? Volunteers?
I can tell you in the ad tech space, there are a lot of companies that have the do not sell button ended up there, but they are probably companies you've never heard of, even though you've interacted with them every time you're online, because they are part of the ecosystem that serves you ads. So actually, I think something that's very interesting with the feature that Facebook just pushed out where you can control how your data is shared with third parties off the platform. One of the interesting parts is you can see what companies have uploaded lists that have matched with data on Facebook. And if you click, the UI is actually pretty good. Joseph, I'm impressed. You can click and it takes you to those websites, to the companies. And you will see do not sell my data on for a lot of those companies, because those are the data broker or the marketing technology layers that you don't know the names of the companies, but they're the ones that you will see the do not sell my data.
So the company I work for is a processor. We actually don't sell data, so we don't have, like I said, you wouldn't know it as a consumer. But I have noticed some websites, I think Williams-Sonoma, maybe Sirius, the radio station, Pandora. If you use any of those, they do have a do not sell button, but Google, Facebook do not.
So if you, as a follow-up on this question, if you as a consumer want to limit to the highest extent possible the trafficking in the data around your own identity. What advice can you give us that will allow that?
I think I can take a first answer at that. I mean that there's a companion law to CCPA, which is a data broker registration requirement. So organizations that sell data and do not have a relationship with you are going to have to register with the AG, and that's going to be online. It's already online. Organizations are registering. So you could visit that page and opt out from those organizations selling your data. To the ad ecosystem, and it is true that a lot of organizations in the ad ecosystem are taking this position that they might sell data. I don't know how they're thinking about minors, because if you have a 14 or 15-year-old using your services in some way, it's not an opt-out. It's actually an opt-in, and if it's under 13, you have to find the parents and get the opt-in from them. So there's a lot of exposure, and to be honest, organizations were really confused as to what choice to make, because there was not enough granularity in what actually selling data means. But there's a fairly large amount of exposure, I would say, in the ad ecosystem in terms of potential enforcement from the AG. Or tips for people, I mean, get Andy's app, right?
Just a quick point on the opt-out side. We pay a lot of attention to retailers who advertise on our platform, and most of them are putting a "Do not sell my personal information" button on their site, but they're burying it at the bottom of the page, down with all the other things, so not many people see it. And one perverse outcome that I don't think many folks anticipated is that the people who are doing that are feeling obliged to pass along those opt-outs to people with whom they share that data. And arriving on my desk today were 2 envelopes from 2 advertisers of relative significant size, with printed pages of email address, name, address, all the personal information for thousands of people that had exercised opt-outs. That cannot be privacy enhancing to have that sitting on my desk in an envelope collated that way. So this is one of the bad outcomes.
Well, if you had 2 in a desk, I'm glad it was yours, because it could have been worse, but you're absolutely right.
I would just say that I think a lot of companies went through sort of a hesitation. Is this something that we should consider? Is there a way to say, it's not really a sale? You know, California passed a draconian law and we don't sell data, but here's our do not sell opt-out. And to me, this is a little bit, again, my wife is Swiss, and just to bring it back to the Swiss gave up financial privacy, like maybe 6 months before Edward Snowden and all of that stuff broke. And so I think a lot of companies are actually underestimating. I understand why companies have done it in the retail space, but I think they're underestimating this big shift that's happening, where people are going to want privacy-forward products and services. And there was a discipline that CCPA and GDPR forced of understanding who your vendors are, who your relationships are. And it's 2 ways. It's those companies also saying, this is now an expectation, and so we need to get organized. And so now that companies are fulfilling data subject access requests, and it's actually challenging to do, there's further automation and there's further reformation of those relationships to take data out of scope. And so I think, again, I hate to say it, I see it as positive.
I actually,
For sites that you use, check out the privacy settings that the companies offer. Because I think for a lot of companies, when they went through the analysis, they may have come to the conclusion, we already offer choices to people who use our services, and we give even more choice or more granular choice than a very blunt tool, do not sell my data button, which doesn't actually explain what's actually happening. So from a what can you do, the services that you use, if you are curious about what the privacy settings are, I encourage you to take a look at those, because you probably will get more control over your data than through that button.
Okay, thank you so much. We're gonna end the questions here, and we will mingle a little bit. I'm sure that some of the panelists will be happy to share their wisdom with you after we end the conversation, but again, thank you for hosting this and
Thank
back to you.
Thank you for excellent moderation and what an awesome panel. I think today's discussion beats last night's discussion. Everyone here was Elizabethonian. So thank you all for coming. And thank you for your time.